Well, we cross now live to legal analyst Dr. Paul Ngobeni, who joins us to perhaps unpack some of the implications of the legal decisions. Dr. Ngobeni, thank you very much for joining us and welcome to the program. Your first thoughts and reaction to the judgment that was handed down today?
Thank you for inviting me. First of all, I think other than the political reaction to the judgment should be seen in its proper context. This was a review application where the applicants were asking the court to look specifically at Mr. Mpshe's decision to drop the charges against President Zuma and to set that aside. The court happened to agree with the applicants. But in the great scheme of things, the judgment does not automatically result in the charges against President Zuma being reinstated, nor does it have any implications in terms of the merits, whether Zuma is guilty or not guilty.
All right, let's clear that up because
the kind of judgment.
Yeah, let's clear that up because that seems to be the bone of contention at the moment, and there's a differing legal opinion here. So, in the first instance, the National Prosecuting Authority thought that they had prima facie evidence against the president, and then they laid charges. Then what happens is they withdraw those charges, and then we now hear 9 years later, 8 years later, saying that we shouldn't have withdrawn those charges. Does setting aside the decision of dropping the charges not take us to the point where those charges were initially propped into the space?
Well, that is where the serious problem lies in terms of the entire Zuma case. Even if you look at the decision, Mpshe's decision, that in itself shows that we have a problem of prosecutorial incompetence in this country. What the judge said today, or what the full bench said today, was that the prosecution yet again made another irrational decision. You may recall that in 2003, Mr. Nguga decided that, or he pronounced that he had a prima facie case against President Zuma, but he decided not to charge him. That was also later found to have actually violated Zuma's constitutional rights. That is the decision of the public protector in 2004. And that decision still stands. It's unreviewed. And as you know now, in terms of our new jurisprudence, public protector's decisions are supposed to be given legal effect. Then after that, you had Judge Msimanga, who actually condemned the prosecution yet again, saying that the prosecution had failed to follow the applicable rules. And then after that, you had Judge Nicholson.
All right.
So cumulatively...
So what you're saying is that at this moment in time, the president actually has no charges that he's facing, and that MPA head Abrahams now has to decide whether he wants to pick up the case and charge the president from scratch or not prosecute.
That is correct. Remember, the case was withdrawn. Mpshe made his decision, and then later the case was withdrawn from the High Court in Durban.
All right, but the decision was made irrationally, we're told.
Right, but that does not automatically bring back the charges. It simply means that the new NPA director, Mr. Abrams, will now have to look at the case.
All right.
He can still make the same decision, provided the reasons he advances are lawful and rational. But that doesn't preclude him from actually making the same decision as Mpshe, but going to the judiciary, as the judgment seemed to suggest, that he needs now to go to court. And in this case, if the prosecution and the accused, that is Mr. Zuma and the prosecution, are agreed, they will approach a judge who would look at the fact that this is a case where both parties are in agreement that the charges should be dropped.
All right.
And you may have a
Dr. Ngobeni, I'm running out of time, so just one important question.
Yeah.
The spy tapes, political interference. Has that been now taken out of the equation for Mr. Abrahams if he has to decide whether to prosecute the case or not? Because the advocate Mpshe was suggesting that he couldn't prosecute on the basis that there was political interference. But it sounds like the judgment says that even if there was, this case was withdrawn irrationally.
Well, the spy tapes are still central to the case. Because remember, when Judge Nicholson made his decision and the Supreme Court of Appeal said there was no evidence substantiating the fact that there was political interference, now we have it on tape. And that came in after the SCA decision. So it's unavoidable. Mr. Abrams is going to have to confront the fact that prosecutors lied under oath. Mr. McCarthy submitted affidavits in which he claimed that there was no political interference, that he didn't consider any extraneous factors in deciding to charge Mr. Zuma. But we now know that the evidence is actually there. So when you talk about abuse of process, even if you take the case to a judge, the judge will have to be offended by what occurred in this case. The lying, the political manipulation, and those who are talking about equality under the law seem to be having a very biased view in terms of the equality, because Mr. Zuma is also entitled to the same equal treatment that we all get under the law, which means that you do not charge him based on political events or on political advantages that you will get from bringing charges against him.
All right, we're going to have to leave it there, but thank you very much indeed for offering us your legal opinion, Dr. Paul Ngobeni. And this is one of those legal issues I'm sure that people are going to be debating over the next couple of days and arguing amongst lawyers, let alone us lay people. We'll have more news for you after the break.